All right, we diving into part two. Are you ready for part two? For the ones that watched part one, get geared up for part two because, like I said the first time, it's explosive. And for those that don't know me, this is Antonio with Team Tiggio. Subscribe to the video, hit the notification bell. You can support this channel through Cash App or Super Chat. This is a TPO case of stalking, distrust, AirTags on the car seat, dad showing up unannounced, mom catching dad showing up unannounced. He's in fear of his life, quote unquote. She's in fear of her life. It's a straight out of a lifetime circumstances that takes place in Judge Manning's courtroom. So don't hesitate. Subscribe to the channel, hit the notification bell. We're about to drop this content, and then we're going to come back and tell you how we feel about the case.
I don't know.
You don't know whether your attorney has authority to speak on your behalf, Mr. Peters?
I know that she's my representative, but I don't know that to be true. But
Mr.
Okay.
Peters, hold on, Mr. Alexander. Okay, Mr. Peters, I think you're thinking way too much about some questions. So we're going to nip this in the bud.
okay. Thank you, Judge.
Okay, so when Ms. Willis says, here's what Mr. Alexander has said, how would you like for me to respond? I can respond this way or this way. And you say, yes, make this offer. So obviously, you know that she sent this, and that's what you gave her permission to say.
Yes, absolutely, Judge.
Okay, so when he says that, if she said something, which I'm sure Ms. Willis wouldn't, but if a lawyer says something that you'll give them authority to do, then they're acting outside of your authority. So he says, when she says something, unless you say, no, I told her not to send that email, that's different, okay? So she does have authority, basically.
Understood, Your Honor. Thank you for clarifying it. And I'm not trying to be difficult. I just want to make sure that I'm being as accurate as possible.
I understand. So don't make Mr. Alexander's question super hard, okay? Don't overthink it. Go ahead, Mr.
Understood.
Thank you, Your Honor. Mr. Peters, is the subject matter, the subject line of this email, Peters versus Peters, is that correct?
It is correct.
And this was sent to, as far as you are aware, your wife's counsel at the time, Miss Eleanor Hitt.
Yes, that's her lawyer.
Okay. This time I would move to admit Respondent's Exhibit 7 into evidence, Your Honor.
Judge, I'm going to object on the ground of relevance. On direct examination of Mr. Peters, tried to address this exact issue, got a relevance objection from Mr. Alexander. The court ruled that it was irrelevant to these proceedings, and therefore I would object to it now coming out on cross.
Mr. Alexander?
I believe the objection was a lack of foundation, Your Honor, because the question, and again, this is based on my recollection, was to the extent of, was there an agreement between counsel of which you were not aware? And that is what I objected to, because I was unaware of what agreement we were even discussing. So the objection was based on lack of foundation, not based on lack of relevance, Your Honor.
Well, I think every objection you made was relevant. There's nothing foundation. So what is the purpose of this?
The purpose of this, Your Honor, is this, I would proffer to the court that this exhibit would show that there was an agreement between counsel that Mr. Peters would not enter the former marital residence. And I believe that is particularly relevant to some of the allegations that were raised with regards to the December 24th incident, as well as actions that were subsequent to that, again, which go to Mr. Peters' allegation that he is in reasonable fear for his safety.
Willis?
Judge, again, I'm going to object on the grounds of relevance. Mr. Alexander objected on Friday, and I'll agree with his objection now. This has nothing to do with the facts that have been presented to the court and the issue of whether or not my client was in reasonable fear for his safety. And therefore, it should not be presented before the court today.
Mr. Alexander, is your position that he went to the home at one point when there was no consent?
On multiple occasions, Your Honor, that's correct. Following this email.
So tell me how that is relevant to the TPO. The Mr.
Well,
Peters speaking against Ms. Peters.
Mr. Peters has made numerous allegations, including based on an allegation of what occurred on December 24th, that he was afraid for his safety. There is evidence which I intend to present of Mr. Peters subsequent to this December 22nd email, where his counsel said that he would stay outside of the house, where Mr. Peters entered the home without even announcing his presence. And certainly that would go to his whether he was actually in fear for his safety, Your Honor.
I mean, I'll just accept. I'll let her be direct on something, but I mean,
Sure.
for the limited purpose of the fact that they said, you know, they would tell each other they were coming over and get approval and consent. That's fine.
Thank you, Your Honor. Mr. Peters, the date on this email is Thursday, December 22nd, 2022, correct? Do you see that?
Yes.
I'm sorry, could you speak up for me
Yes.
a little bit, Mr. Peters? Okay, thank
Yes.
you. And then can you please read this last portion, which I've just highlighted?
Additionally, my client needs to retrieve some of Henry's personal items for the stays. Other than this, we agree that neither party shall enter the home where the other party is staying unless by consent.
Okay, thank you, Mr. Peters. And on December 24th, did you enter the home?
Yes.
Okay, did you knock on the door and ask if you could come in first?
No.
Okay. Did you just have a key and you used the key to open the front door?
Yeah, I have a key. I still have a key.
Okay. You testified based on all of the allegations in your petition, I believe even going back to November 18th, when you testified that you first discovered the AirTag in your son's car seat, that you were afraid for your safety. Is that correct?
Yes. I mean, I was afraid for my safety before that, but certainly yes.
All right, and you had no concerns, though, to just walk into the house without even knocking on the front door or ringing the doorbell on December 24th?
No, I had many concerns, and I was certainly afraid in that situation, but I had to do it in order to see my son.
You couldn't have knocked on the front door?
In my history of going in and out of that house where, you know, I was on the lease and was my residence, I had never knocked on the front door prior to entering. And I wasn't aware of this email or this agreement between the attorneys. My understanding was that I was supposed to show up at the house based on Candace saying pick him up at the house, or texting to say pick him up at the house. So my understanding is that I was supposed to go to the house and collect Henry. So that's what I would,
Mr. Peters, let me remind you, first word out of your mouth, any of his questions typically is yes or no, and then an explanation.
Understood, Judge. I'm sorry, and I will.
Go ahead, Mr. Alexander.
Thank you, Your Honor. So, Mr. Peters, I just want to be sure that I am clear about this, that historically you have said you have been in fear in the past. That's correct?
And I am still in fear. I'm sorry, Your Honor. Yes.
And I'm sorry, you can go ahead. And you said you're still in fear?
I am still in fear today. Yes.
Okay. And so it has always been your practice, though, to just, I'm assuming, correct me if I'm wrong, to just walk into your front door.
No. Sometimes I would walk into the garage door or into the back door or to other doors of the house. But in general, you are correct. My practice when going into the residence, when I had a key or when it was to open the door and go inside.
And so is it your testimony then that none of your conduct changed or should have changed as a result of any of the ongoing litigation or you finding the AirTags?
I don't know. You asked two questions there. that it
Well,
did my
then
conduct
I will
change, but
I will
or should it have
rephrase that.
changed?
To be clear, Mr. Peters. So
Okay.
let me start with the first one. Based on the litigation with the divorce and the temporary protective order that's now in place, you don't believe that your historical conduct of walking into the front door of the house without knocking or ringing the doorbell is proper.
Son, I don't believe I'm tracking the double negatives there. I think the answer to that is no, but I can explain, which is
Mr.
simply
Peters, you testified on Friday that it was typical conversations of Miss McCowan Peters to curse at you and to use violence towards you. Is that correct?
yes,
Okay. And you testified as well that in the past you used to flee from that type of behavior, correct?
often, yes. Yes,
You testified that now you feel you cannot flee as a result of y'all having a child together, correct?
that's not what I said.
Okay. So do you feel that nothing has changed such that you should just enter the front door of the house at this point in time?
This point being February 14th,
I'm at, yeah,
2023.
February 14th. We'll work backwards from there. February 14th.
I should not enter the house with without asking her permission as of today. That
And it's your testimony that on December 24th, you walked in the house scared for your safety.
yes,
So why did you just walk into the house?
because I needed to do that in order to collect my son. I was there because I wanted to see Henry. That was the opportunity that had been provided for me to see him. And if I didn't overcome my fears, then I wouldn't see my son. And so I did it in order to see him.
So you could not have rung the doorbell?
I could have rung the doorbell, but I was there in general, afraid, but nevertheless overcoming those fears because I wanted to see Henry.
You couldn't have knocked on the front door?
I could have knocked on the front door.
You couldn't have called Miss McCowan Peters and said, hey, I'm out front?
I could have called I could have called her. Yes, I could have called her. There are many things that I could have done, but my practice when going to the house on December 22nd and prior was to open the door and go inside.
And all those other times you walked in, you were in fear for your safety?
Not every time that I walked into the front door of the house was I in fear, because sometimes she wasn't there.
So every time
Sometimes.
your wife was at home and you walked in the front door, you were afraid?
During the period of time that we're talking about here today, yes.
I'm sorry, then I'll ask you that period of time. Are you talking about subsequent to November 18th, 2022?
Yes.
Okay. So your testimony, I just want to be clear, is you were afraid. You walked in, though, because you were able to overcome your fear, correct?
Yes.
Okay. And then December 24th, that's the date on which you alleged to the court and to the police that you were slapped by Miss McCowan Peters, correct?
Yes.
Okay. Were any arrests made as a result of that police report that you filed?
Not to my knowledge.
Okay. Were any charges filed to your knowledge as a result of the police report?
Not to my knowledge.
All right, Your Honor, I'm going to share my screen if I may. Mr. Peters, I'm going to show you the police report that has actually already been introduced into evidence by your counsel. Do you recall that?
I recall this, yes.
Okay. And do you see this last portion that I'm highlighting right here? I'll ask you to please read that for the court.
Due to not having clear audio or video footage, I was unable to conclude who the primary aggressor was during the incident. Both parties were provided a case number and information on how to retrieve the report. Both parties were also advised to have their lawyers be the ones to contact either party going forward.
Okay. And I'm going to get you to read one more piece for me, Mr. Peters, while I find this. I apologize. Will you please read this sentence right here, beginning with the word "while," which I just highlighted?
While trying to put the jacket on the son, Mrs. Peters said Mr. Peters grabbed her by the arm.
Okay, thank you, Mr. Peters. I'm going to ask your counsel to. I apologize. Did you in fact grab Mrs. Peters by the arm during that incident?
No,
Did you put your hands on her in any way during that incident?
I did not.
Think anything would refresh your recollection to that effect?
It didn't happen. And so, no.
Then I'm going to ask you, because this has already been introduced into evidence, I'm going to ask your counsel, because she is in possession of it. I apologize. Otherwise, I would certainly play it, Your Honor, to play the recording from that December 24th incident, which, like I said, has already been introduced into evidence. Ms. Willis, could you pull that up?
Yep, give me just a second.
No problem.
I apologize.
No, you're fine. I put you on the spot on this one.
We're just moving this around too in the file, so give me 2 seconds and we'll find where it was saved. Okay. I have it pulled up.
Okay, if you could go ahead and play that for me, and I'll let you know when to stop it. Thank you.
Okay.
You said that. No, you need to go. You need to fucking go. Whoa. Guys. Whoa. Whoa. You need to go. Stop. Stop. You get the fuck out of me. No.
I believe, if I recall correctly, there's more to this. That there was a little gap.
I mean, I can show you where I started this. If you would like me to screen share, I can.
That would be great. This is the recording that was entered for the December 24th incident. I don't remember what number that was. My apologies.
P8. You see that I'm starting from the beginning?
I do. Was this entire recording played during the initial direct examination, Ms. Willis? I apologize.
I believe this is the one where, yeah, I believe the whole thing was played, but I'm not entirely sure.
Okay. If you could go ahead and hit play for me. And like I said, I'll let you know when to stop.
You said that. No, you need to go. You need to fucking go. Whoa. Guys. Whoa. Whoa. You need to go. Stop. Stop. You get the fuck out of me. No.
Bullshit. I understand. It's awesome.
Will you go ahead and stop it right there, Miss Willis?
And
Am I good to stop sharing my screen?
You can go ahead and stop sharing. Mr. Peters, would you agree with me that on that audio we just heard that Miss Peters could be heard saying, "Get your hands off of me"?
Like that.
All right, Mr. Peters,
Yeah, I'm
You
sorry.
go ahead.
Yeah, something like that. Yes.
Okay, is it still your testimony that you did not put your hands on Miss Peters at all during that incident on December 24th, 2022?
I didn't. In fact, I think you immediately heard me say in the recording, I'm not touching you.
So following your incident on December 24th, 2022, would you say that your fear for your safety increased following that date?
Yes.
Okay. And as a result, did you change any of your behaviors with regards to entering the home?
What do you mean by that?
Well, we just extensively went over that historically you would walk into either the front door, the garage door, or the back door, correct?
Yeah.
Following the alleged incident on December 24th, 2022, did you change any of those behaviors in terms of how or if you enter the house?
Certainly. Yes.
Mr. Peters, stop. Stop. Whatever you got going on with the earphones, the audio is horrible. You fade in and out, and
I have another pair here, Judge, or Your Honor. Should I try those?
well, I mean, the other day I don't think you had on headphones, so I'm not really sure why you're doing it because they usually are horrible. Using audio, I mean, they're bad when you try to talk to somebody on the phone.
It's better.
Perfect.
better.
Now, answer the question. Were you more afraid on the 24th? Did your fear increase is what he's asking.
Yes.
Lean
And-
forward. So 20.
Yes.
Okay.
Your Honor, it is 10 o'clock. I just didn't want to.
Yes. Ms. Freed, did you have the ex partes on video pulled up? She might be pulling it up. Go ahead and ask your next question.
And I believe the question was, given that your fear increased following the incident on December 24th, did you change any of your behaviors in terms of entering the house upon arrival to get Henry after December 24th?
Yes. I think subsequently this TPO was requested, and we requested that he be exchanged at a fire station or a police station.
So is it your testimony that you did not enter the home without knocking on the door or ringing the doorbell subsequent to December 24th?
The next time I picked Henry up, first of all, no, that is not my testimony. The next time I picked Henry up, I followed the same practice as prior, but I did so having called Miss Willis, called my other attorneys to ask them what I should do, and also having called the police and filed a police report, which, I called the police immediately after this. So, but nevertheless, I still had to go, collect my son if I wanted to see him.
And so you did, in fact, just walk in the front door next time you went to the house after December 24th, did you not?
I did, yes.
And your testimony is, again, you were just overcoming your fear when you did so?
That's not no, that's not what I testified to. I was there collecting my son which required me to overcome my fear. But to your specific question as to why I opened the door and went into the house, it's because that had been my practice, and because this incident, the attack, the verbal attack, the profanity, the slapping, if you listen to it, or the entire it wasn't because I walked into the house and all of a sudden she was attacking me. She got there and spun herself up as a result of what happened prior. But it wasn't, she didn't say, well, I'm slapping you because you walked into the house. She slapped, if you listen to the tape or the recording that was just played, what she's saying is, give me the coat, give me the effing coat, give me the coat. She's literally demanding that a coat that my family had bought for Henry and that I was holding in my hand, that I hand over to her. So she's not riled up because I walked into the house. She's riled up over a jacket that I had bought for Henry.
Mr. Peters, your test.
Right there, Mr. Alexander. She just texted me and said they're ready.
Yes, ma'am.
All right, Mr. Alexander, go ahead.
Yes, thank you, Your Honor.
Hold on, everybody turns theirs on. And let's please be very conscious of the fact that, one, I have another case this afternoon, but two, we put this on because Ms. White sacrificed her leave of absence. But let's be real cognizant of the fact that it is her day off and her birthday. So let's keep
Yes,
it
ma'am.
moving, okay?
I can move along and
Okay.
finish rather quickly. Thank you.
Madam Court Reporter, are you still here?
I just got back.
Oh, okay.
Oh, wait.
All right. Okay, go ahead, Mr. Alexander.
Thank you, Your Honor. Mr. Peters, you testified previously that one of your fears is with regards to Ms. McCallum Peters is being assaulted or struck, correct?
Yes.
Okay. And so it's your testimony that you, despite this fear, walked straight into the person's house of which you are afraid, without knocking or without ringing the doorbell or without calling ahead.
I think we have beat that dead horse. He said he walked in.
Mr. Peters, do you have any pictures whatsoever of any of the cameras you alleged to have found in the residence?
Yes.
Yet you decided not to introduce any of those into evidence on during your direct examination?
No, I didn't make a decision on what to introduce into evidence on direct. I provided the images that I have to my counsel, and I think it would be fair to say that she made the decision.
Okay. Do you have any physical evidence of any text message or written threats made to you by Ms. McCallum Peters?
I don't know. I don't know. I'd have to look at my emails and text messages.
Do you have any pictures of any physical injuries that you have ever sustained by Ms. McCallum Peters?
No.
Mr. Peters, you testified on Friday that when you reviewed this petition for temporary protective order, you did so solely for its veracity. Do you recall that?
Yes.
Okay. And you have filed a petition for divorce against Ms. McCallum Peters, is that correct?
Yes.
Okay, I'm going to, Your Honor, with your permission, share my screen, and then I will be wrapping up very shortly, Your Honor. I apologize. So. I'm going to show you what's been marked as respondents exhibit 14. Is this your complaint for divorce, Mr. Peters? And let me know if you'd like me to scroll through the whole thing.
This is it. Yes.
Okay, and you reviewed this for its veracity as well, yes?
Yes.
Okay. First, Your Honor, I'd move to admit respondents 14 into evidence.
Willis, I'm sure you don't have an objection because I could take judicial notice, so it's admitted.
No objection.
It's
Thank you,
admitted.
Your Honor. Mr. Peters, this was filed December 13th, 2022, correct? See that at the top?
Yes.
And you reviewed this for its veracity as well, is that correct?
Yes.
Yeah. If you please go ahead and read for me right here, paragraph 1, please.
I'm sorry. Petitioner has been resident of the state of Georgia for at least 6 months prior to the date of the filing of this petition.
Have you in fact been a resident in the state of Georgia for 6 months prior to December 13th, 2022?
Yes, that's my belief.
Objection, Your Honor. Relevance as to this line of questioning from the divorce complaint. This is a TPO hearing.
Mr. Alexander, what in the world?
Your Honor, he's testified that his leaving out of certain allegations are solely, and he was a decision of counsel. He solely reviewed these things for veracity. There is testimony that's going to be elicited that he has not been a resident of the Georgia for 6 months, and he's put this in an official pleading. This goes to credibility, Your Honor.
I think you can take that up in front of the divorce judge.
Correct, Your Honor. However, my position is that it goes to overall veracity and credibility of the petitioner in this action.
All right. He says he thinks he did. Next. So we've covered that. He says he thinks he did. I've taken judicial notice. Next. So if you're going to have somebody say he didn't, that's all I need.
Mr. Peters.
Mr. Alexander, I think I'll let you know I'm done with 18,000 of these. I know exactly what I need to hear. I promise.
Thank you, Your Honor. Mr. Peters, was it your intention by filing a police report on December 25th, 2022 for Ms. McCown Peters to be arrested?
Okay, Mr. Peters, this is not a hard question. I'm not sure what the pauses are. No.
Yes. Yeah, it was.
You are an intelligent man, but you don't have to think that much if you wanted her to go to jail or not. So please, I know you want to think, but not that long. It's a yes or a no. Go ahead.
Yeah, yes, Your Honor. I certainly wanted her to be charged. I certainly wanted her to be prosecuted. Your Honor, yes.
Okay. Go ahead.
So, Mr. Peters, you brought this TPO then as a result of not getting what you wanted on December 25th, 2022, yes?
No, actually, I had gone to get a TPO prior to December 24th, went through the process, actually went to Safe Families and had a discussion with them and met with their attorney and so forth. And, decided at that time that I wanted to think about it more. So I'd actually been into Safe Families prior to December 24th. And it was really only after this incident on December 24th, calling the police on the 24th and then filing the report on the 25th and speaking to Ms. Willis subsequent to this, that it became clear to me that I did need a protective order. So the December 24th was not the first time that I had been down to the courthouse to go through the process and talk to Safe Families about a TPO. That had actually happened like days before this incident. But what this incident on the 24th did was crystallize that the advice that I was receiving at Safe Families, that I really did need a protective order, that advice, which I had gone against and not pursuing it for going forward with the TPO earlier, that advice was correct and that I was wrong in not going forward with it previously.
Okay, and so, but you didn't listen to that advice because you were not in fear for your safety, yes?
It's not that I did incorrect or no. It's not that I didn't listen to the advice. It's that I didn't, when they finally put the petition in front of me, I didn't really have the conception of myself as and by the way, I talked to other people that were in there getting TPOs. I didn't really think of myself as like, sorry.
Your lawyer will ask follow-up questions if it needs to be explained, because you were just going way out around 285.
I'm sorry, Your Honor.
That's okay. Go ahead, Mr. Alexander.
So then, Mr. Peters, what you are claiming here right now is the assault that occurred on December 24th is what was the impetus for you to ultimately file the petition for temporary protective order. Is that right?
No. As I mentioned, I had gone down to file a protective order earlier, ultimately decided, let's say, to not do it that day, to think about it once I understood more about it. This incident on the 24th crystallized that I needed one, and I went in to get a protective order. I would have done it on the 24th or on the 25th if that had been a normal day of if that had been June 25th, but it was December 25th.
Okay, so then to put it better, then that was the incident on December 24th was the nail in the coffin for you making that decision?
Sure, the straw of the camel and so on.
Whatever we want to say, right? But you didn't include anything about that incident in your petition for temporary protective order, did you?
No, as I mentioned, you know, we went through, I think last time, how that petition was actually drafted and what I reviewed it for.
Okay. I have no further questions at this time, Your Honor.
Anything else, Ms. Willis?
Just a few, Your Honor, clarifying questions. Mr. Peters, when we first discussed filing this petition, were we talking about a family violence TPO or a stalking protective order?
Stalking.
All right,
Your Honor,
and
if I may, just for some guidance from the court, and obviously this is Mr. Peters' privilege of which to waive or not to waive. I just want to be clear that they're going to be testimony about discussions between counsel and client.
Well, I can probably help this. He came to take out an original stalking order. I advise them they're married and it falls under family violence.
All right. And is the reason that you didn't include the December 24th action in the petition is because it was a stalking petition and not a family violence? Was that a yes?
Yes.
Thank you. On December 24th, when you went to the home, were you there to retrieve Henry's belongings?
No, I was there to collect Henry.
Did you also need to collect some belongings for him or no?
I did not.
Even a jacket for him?
I had purchased a jacket for him that was a Christmas present, and I had it in the car. So I had my own jacket for Henry.
Okay, when you got there to get him, did he have on a jacket ready to leave the house?
No.
Okay, and when did this conversation between you and Ms. Peters turn sour?
As you can hear on the recording, when she's demanding that I hand over the jacket that I bought him for Christmas, and so that she could put it on him, and I was simply saying no. I was perfectly capable of putting it on myself.
So when you first entered the home, was she angry with you then?
She wasn't cursing at me and using profanity and yelling at me. No.
Sure. Nothing further, Your Honor.
Anything else, Mr. Alexander?
No, Your Honor.
Mr. Peters, I have one question. I want a direct answer. The 3 AirTags, baby wipes, car seat, and the other one that you found?
Carriage of the car, Your Honor.
I had put on the part I didn't. That's what I thought. Okay. All right. Ms. Willis, any other witnesses?
No, Your Honor.
All right, Mr. Alexander?
Your Honor, again, I'm just going to move for the record again for a directed verdict here. I don't believe he has proven any of the elements necessary here, that he's in reasonable fear for her safety, that there is a pattern of harassing and intimidating conduct. Certainly, again, to the extent that these 2 cameras are predicate acts, they occurred in respondent's home, thus they are precluded by statute. And I do not believe there are any exceptions to that whatsoever, regardless of access to areas of the home. Additionally, Your Honor, there has not been any evidence other than testimony with regards to cameras that were alleged, or any acts of physical violence to that effect, any threats. That we heard some cursing, but again, it is petitioner's burden to prove all the facts related to stalking by preponderance of the evidence. And I would, as a result, move for a directed verdict that he did not do so.
Willis?
Judge, I'll keep it brief. The stalking statute specifically provides that it is not a requirement that fear of bodily harm be required to prove the elements of the stalking statute. He has testified numerous times that he was afraid of Miss Peters and her violence. We have played audio recording showing her aggressive behavior. And he has again testified numerous times about his reasonable fear. As far as the cameras go, I had the pleasure of doing some research over the weekend, and the court has not specifically addressed any sort of issue on whether or not surveillance falls under the same, that surveillance in the respondent's home covers areas that are exclusive to one party. The case law is pretty clear that where that applies is where the victim has entered the respondent's home and there is and then tries to raise the issue of surveillance. Furthermore, even if the court does find that the cameras in the home do not fall under the surveillance portion of the statute, certainly the AirTags have the petitioner's testimony regarding the AirTags fall under the purview of surveillance and under the stalking statute, and there can be no argument that that was not in the respondent's home.
I'm going to deny your motion of directed verdict. I'm going to call your witness.
Yep, thank you, Your Honor. We'll call Miss McCowan Peters for to the stand.
Mr. Peters, I'm going to place you back on mute because the only three people that should be talking is Miss Willis, Mr. Alexander, and Miss McCowan Peters. Miss Peters, you want to test your mic, make sure the court reporter can hear you?
Yes, ma'am. Can you hear me?
Yes, thank you.
Ms. McCowan Peters, I believe you are still under oath, though you did not testify. So I just want to remind you of that fact, okay? Ms. McCowan Peters, did you read the petition for temporary protective order that was filed against you by your husband, Mr. Peters?
Yes.
So I want to go through some of those allegations with you. Did you read the first allegation that your husband found a hidden wireless camera and microphone buried inside his office equipment that was located in the basement of your residence where he has a home office? Did you read that?
Yes, I read that.
Okay. Did he in fact maintain a home office in the residence?
He would work from our residence, but worked in multiple locations.
Okay. Did he maintain one main office within the residence?
For much of the time he did, and it was upstairs just off the kitchen, but would often move around.
Okay, Your Honor, I'm going to share my screen with your permission. Ms. McCowan Peters, I'm going to show you what I have marked as Respondents Exhibit 12. You recognize this?
Yes.
And can you briefly describe for the court what it is?
This is a little office area off the kitchen in our townhome.
That's enough right there, Ms. McCowan Peters. Is it a true and accurate representation?
Yes.
Your Honor, at this time, I'd like to move to admit Respondents Exhibit 12 into evidence.
No objection, Your Honor.
Okay, it's admitted.
And Ms. McCowan Peters, I apologize. I interrupted you. You were saying where this is located in the home?
Yeah, this is on our main floor of our home. That's an open floor plan. This is just off the kitchen area. But like right next to it is also a dining room area as well.
Okay. And are the printer, laptop, those items in this picture, are those Mr. Peters?
Yes.
Okay. And are these items he would traditionally use for work?
Yes.
And did you place a camera at any point in time in this area of the residence?
No,
Okay. Did you, in fact, place a camera in the basement at any point in time?
yes.
Okay. Why did you do that?
We had 3 cameras prior when we lived in a 2-bedroom apartment in New York City, so we only needed 3 cameras. We moved to a larger space here in Roswell, and I didn't think we were going to need a camera on our basement level, but one day I was down there and I found a drum, a teddy bear, several of Henry's toys, so indicating to me that he was spending time down there, and I, as with every other space where he spends time, including his bedroom, wanted a camera down there.
Okay. And if you would, will you describe for the court kind of how the basement was set up at the time? I believe Mr. Peters talked about there being boxes down there. Is that true? Can you please describe for the court how it was set up?
Yeah, since we had just moved back in August into that residence, that there were boxes all over, boxes of his items, boxes of my items, lots of books. There was a sleeper sofa off to one side. I put a lamp up. And then there was a desk down there as well. But it was, there's a bathroom down there, but that's pretty much it. It wasn't.
And
Yeah.
would you describe, I'm sorry, is it still set up like that now, Ms.?
No, it is not, because Mr. Peters has since come in and removed many of his items that were down there, including a lot of the boxes, all the books. So it's not the same situation any longer.
When you set up the camera in the basement, did you bury it in one of the boxes or an office equipment?
No, I set it on top of one of the boxes.
Okay, so when you walked into the room, would it be open and obvious?
Sure, if you were looking for it. Yeah, I mean, it was just among a whole bunch of stuff off to the side.
Okay. And did you read the allegation contained in Mr. Peters' petition that there was a camera hidden amongst cardboard boxes in the garage of the marital residence? Did you read that?
Yes.
Is there actually a camera set up in the garage of the marital residence?
Yes.
All right, Your Honor, with permission, I'm going to share my screen. I'm going to show you, Ms. McCown-Peters, what I have marked as Respondents Exhibit 10. Do you recognize this photograph, Ms. McCown-Peters?
Yes.
Is it a picture of space in your garage?
Yes.
Is it a true and accurate representation of that setup in your garage?
Yes.
Your Honor, at this point in time, I'd like to move to admit Respondents Exhibit 10 into evidence.
Your Honor, I would just ask that he scroll up to the top and to the bottom to see if we might have a timestamp anywhere. Okay. Thank you.
Any
No
objection?
objection.
All right, it's admitted.
Ms. McCown-Peters, is this the camera that is set up in the garage?
It is.
Has it always been set up like this?
Yes, that's the only plug, and this camera requires a plug.
Okay. At any point in time, have you buried these things in the garage?
No.
Historically, has your husband, and I'll stop sharing that. Has your husband worked in the garage?
No.
Okay. Does he stay overnight in the garage?
No.
Would you have any reason whatsoever to set up a camera in the garage to surveil Mr. Peters?
No.
Okay. Did you hear Mr. Peters testify that you have been violent towards him in the past?
Yes.
Okay. Have you ever cursed at your husband?
Yes.
Okay. Have you ever threatened to physically harm your husband?
No.
Have you ever struck your husband?
No.
Okay. Did you hear Mr. Peters' testimony regarding what occurred on December 24th, 2022?
Yes.
Okay. Do you agree with his version of the events?
No.
Can you please describe for the court what occurred on December 24th, 2022?
Yeah, under advice of my counsel, was that I have somebody with me every time there was a custody exchange. So my two brothers were there. We were sitting in the living room with Henry, giving him a bottle because he'd just gotten up from a nap. And I was waiting on Mr. Peters to arrive, expecting a knock or a text. And we were going to take him outside and make sure I have witnesses. Instead, we're sitting there and I hear the front door open, which is alarming. So I get up and run over there and it's him. And I say, hey, there's an agreement from our attorneys that you're not supposed to be in the house. And he says, I don't know anything about that agreement. And I said, well, I'm telling you now, you're not supposed to be in the house. He had moved out. I can bring Henry out to you. Give me just a minute to finish his bottle. No, I'm not leaving. I'm on the lease. And I was like, okay, give us just a second. We'll finish the bottle. And I was upset at this point because I'm like, you shouldn't be in my house. It just felt a little bit violating for somebody who had moved out on the 18th. So,
Ms. McCowan-Peters, I'm going to stop you right there and I'm going to show you what I have marked as Respondents Exhibit 8. Do you recognize this photograph?
yes,
And is this a photograph of your husband in the doorway of your marital residence?
it is.
And is it a fair and accurate representation of the incident, or I'm sorry, the representative of this photograph at the time of the image in this photograph?
Yes,
And did you take this photograph on December 24th, 2022?
yes.
Your Honor, at this time I'd move to admit Respondents Exhibit 8 into evidence.
Any objection?
No objection, Your Honor.
All right, submitted.
Thank you, Your Honor. And Ms. McCowan-Peters, when you say that Mr. Peters entered the home, is this how you found him?
Yes.
Thank you. After he entered the home, please go ahead and continue with what occurred following his entry into the home.
I think one of the next things I did was walk back into the living room area to grab my phone to take this picture. And then I said, Henry's jacket was missing from another day when Mr. Peters had taken him. And so I said, hey, he needs a coat. And he said, yeah, I've got one in the car. And it was one of those days when we were having that like polar vortex and it was below 20 degrees. I'm like, no, he needs to put it on to go to the car. So he went to go get it. And I asked to put it on him. He said, no, he was just being difficult for no reason. And then I tried to grab it from him and that's when he grabbed my wrist. I said, hey guys, to my brothers, so that, so they like this new, and, then, he and I both put the jacket on Henry, and I gave him the diaper bag, that is always used for Henry by me, my parents, the nanny, everybody. I gave him the diaper bag, and they left.
Okay. Did you at any point in time slap Mr. Peters across the face?
No,
Okay. And at any point in time, did you direct either of your brothers to physically harm Mr. Peters?
no,
Okay. At any point in time, did you threaten him with violence if he would not get out of the house?
no,
Okay. Was this December 24th incident the only time from that point till now that Mr. Peters entered the home without knocking or ringing a doorbell?
no, he did it again a couple of days later.
I'm going to show you what has been marked as Respondents Exhibit 15. Let me share my screen. I'm not going to hit play on this yet. Ms. McCowan-Peters, do you recognize what this is?
Yes,
Can you please briefly describe for the court what it is?
this is the entryway to the townhome where Henry and I live.
Okay, and was this taken on your Nest camera in the residence?
Yes,
And do you maintain access to those those files?
Yes.
And to your knowledge, has this been altered in any way?
No.
All right, this time, Your Honor, I'd move to admit respondents 15 into evidence.
Any objections?
No objection, Your Honor.
All right, submitted.
I'm going to go ahead and play this for you, Ms. McCowan-Peters. And I apologize, before I hit play, Ms. McCowan-Peters, was this recording taken on December 27th, 2022?
Yes.
Mr. Alexander, I'm not doubting your ability to share, but if it has audio, did you click that include audio when you started to share your screen?
I don't believe that I did, actually. However, I don't even know that there is audio in
Oh,
this.
okay. I didn't know if there was or not, just if there was.
If there is, it's nothing.
Can't really hear it, okay.
And Ms. McCowan-Peters, is prior to Mr. McCowan-Peters entering the home in that video, did he knock on the front door?
No.
Did he ring the doorbell?
No.
Okay. Did he just announce himself upon entering the home?
He didn't even announce himself. He just walked in and we heard him.
Were there any incidences which occurred during this exchange on December 27th, 2022?
No, there was, my mom heard him come in and she's like, he came in again. And I said, yeah, just don't say anything to him about it.
Okay. And do you maintain other cameras in the home other than the garage and then the one we discussed in that was once in the basement?
Yes.
And are any of those in hidden places?
No.
I'm going to show you, Ms. McCowan-Peters, quickly what has been marked as Respondents Exhibit 11. We'll just move through this quickly. Do you recognize this photograph?
Yes.
Is it a picture of one of the cameras set up in your residence?
Yes.
Is it a true and accurate representation of this area as it exists?
Yes.
Okay, thank you, Your Honor. This time I'd move to admit Respondents Exhibit 11 into evidence.
No objection, Your Honor.
Okay, it's admitted.
Is that one of the Nest cameras on the corner of the mantle there, Ms. McCowan-Peters?
Yes.
And is that representative of how the other cameras in the house are set up?
Yes.
Thank you. You heard Mr. Peters testify about an incident which occurred on December 18th, 2022 about a park. Do you remember that?
Yes.
Okay. Do you recall and can you testify for the court about what conversations occurred, if any, prior to Mr. Peters taking Henry to the park?
There was no conversations with me.
Okay.
Go ahead.
I'm sorry, did you have Henry, did he retrieve Henry from you that day to take Henry to the park?
No.
When you learned that Mr. Peters had Henry, did you contact him to check on his whereabouts?
Yes.
And how did Mr. Peters respond to you?
He didn't answer at first, sent me a text, said, I'll call you back. And then eventually called back.
Okay. And when he called back, do you recall what occurred during that phone call?
Yeah, he said, this is my son. I don't have to tell you where I'm taking him. And I don't have to tell you that I am taking him. I told the nanny and that's good enough.
Okay.
And I was saying, no, we should tell each other and communicate, you know.
Okay. Historically speaking, would Mr. Peters tell you where he was taking Henry if he was taking Henry somewhere?
Yep.
Okay. So did you find it unusual that he would, or concerning that he would not tell you where he was taking Henry?
Very concerning because the night prior while I was at work, I saw him on the cameras moving his items out of the house. So I just didn't know where he was taking him.
Okay. And have you, turning to the issue of AirTags, historically, have you used AirTags in the past to keep an eye on Henry's whereabouts?
Yes.
Please describe for the court how you have utilized those AirTags in the past.
Initially, always it's been to keep up with Henry. When we were in New York City, we had the cameras in the house, but when our nanny would take him out, Halton and I had a discussion. He saw me setting it up. I put it in the stroller so that when the nanny Renata would take him out, we would know where he was. We interviewed this woman and she turned out to be a saint, but you don't know that in the beginning. So we just kind of wanted to know where he was.
Okay. And was Mr. Peters aware that you were using these AirTags?
He was.
Okay. And when you moved to Atlanta, did you continue using these AirTags?
Yes.
Okay. How so?
The one that was in the stroller remained in the stroller. There was one that was in the baby bag because different from New York City where you're only walking with a stroller here. Occasionally Lauren would take him to music class, or she would, I think music class might have been the only place that we had said that she was taking him, but for any time they left the house, I would know where they were.
Okay. And the nanny bag that you, or the diaper bag that you're referring to, is that the same diaper bag that you gave to Mr. Peters on December 24th, 2022?
Yeah, it's the only diaper bag we use.
Okay. In whose possession is that diaper bag right now?
It's with me.
Okay. And so you had placed that AirTag in, had you placed that AirTag in the diaper bag immediately before Mr. Peters came to retrieve Henry?
No.
Do you recall about how long that AirTag had been in that diaper bag?
Several months, I would imagine.
Okay. So it's your testimony you didn't put it inside the folds of some wipes?
It was in like a package of like dried out wipes. Yeah.
Okay. And describe for the court, if you will, why you placed an AirTag in Henry's car seat.
Yeah, Mr. Peters has shown very little interest in taking Henry anywhere. And I think it was 15 months into his life, he all of a sudden got a car seat. That among with like, you know, not communicating as much as he was before. Or no, let me just say he's never been a great communicator, but just, you know, expressing to me that he didn't feel the need to tell me where he was going with Henry. And somebody who spends the majority of their time in Florida in another state, I just, you know, it's my duty and my privilege to keep up with my child. And so I put it in the car seat just to understand where Henry would be.
Okay. And if you would, please explain about the AirTag on the undercarriage of the car.
Yeah, as time went on, his like behavior became more, I don't know, just more distant and less communication. Again, just wanted to keep up with my child. I have no interest in keeping up with this man. I don't have time or interest. But yeah, I just wanted to know where my child was. And so I put it on the car to know where he was taking my son.
Okay. Have you ever, since I will say in the last 6 months, have you ever showed up to somewhere where Mr. Peters is unannounced or without him knowing you would be there?
The only time was that day that he came and picked Henry up without talking to me, and it told the nanny he was taking him to the park. And my parents went up to put their eyes and see, you know, if what he was saying was actually true. And I showed up there afterwards, but it was because he told the nanny he was there. My parents could see him there, and that was the case.
And when you showed up on that incident, did you threaten Mr. Peters with violence?
No,
Okay. Did you wag a finger in his face or ball up your fists at him as he testified to?
I'm sure I might have talked with my hands, but definitely didn't ball up my fist.
Okay. Did you put your hands on him in any way whatsoever?
Absolutely not.
Did you hear him testify that you followed him after the park?
Yeah, when I arrived to the park, he was in the car and they were pulling out. So I just turned around and followed to, again, figure out where they were going, and follow them. I guess he took a baby to a sports bar. So
Have you placed any, other than the 3 AirTags that we've been discussing, have you placed any other AirTags whatsoever on any of Mr. Peters' property?
no,
Okay. Is the AirTag still in the nanny bag? Have you placed another one in there?
no, because I just don't want to be accused of trying to keep up with Halton when I'm not. So and matter of fact, I just kind of trust my nanny more than I trust him right now.
Okay. And to the best of your knowledge, when did you and Mr. Peters relocate to Georgia?
Henry and I flew into Georgia on June 30th. Halton flew in the following day, which was July 1st.
Thank you, Ms. Peters. I have no further questions.
Cross, Ms. Willis?
Yes, Judge. Ms. Peters, just for the sake of expediting this, you don't deny that you put all 3 AirTags on Mr. Peters' car, the car seat, and the baby bag, correct?
No, I don't deny the one that's on my keychain either.
Okay. You didn't inform him of all 3 of those either, did you?
No, but I don't tell him everything. So, but he knew there was one in the baby bag. So,
Okay, but he couldn't see the one in the car seat,
I said no.
and he couldn't see the one. I asked if you had told him. I'm asking if he could see it. Could he see the one in the car seat?
I can't testify to what he saw.
Was it visible where you placed it in the car seat?
To me, yes.
Was it visible, the one you placed in the undercarriage of the car, was that visible to someone who didn't know was there?
I don't know what somebody else, you know.
All right. You would agree with me that Mr. Peters drives his car to places other than where he is with Henry, correct?
Yes.
Would you agree with me that there's no reason for you to be tracking his movements when he's not with Henry?
Absolutely. I agree with you.
Okay. You informed the nanny of the AirTag that you placed on the stroller, correct?
I don't know that I did. No.
It's your testimony that you did not inform the nanny in New York about the AirTag on the stroller.
I don't recall informing her.
Okay. Did you inform Lauren about the AirTags that you placed on the baby seat?
No, I didn't.
Is it your understanding that Lauren has knowledge of the AirTags?
I don't know.
Okay. So is it your testimony that you never had a conversation with Lauren regarding any AirTags?
I don't remember having a conversation with her about AirTags. I had a conversation with her about cameras.
Okay. You presented 2 photos of cameras in the home today. The one in the garage, correct?
Mm-hmm.
And the one by the TV, correct?
Yes.
But you didn't present any photos of the one in the basement, did you?
Well, the one in the basement isn't there anymore because your client moved his stuff out. And so there's no boxes for it to actually sit on. So it got moved in the shuffle of that. And now I just put it on my front door. So it's not in the same place anymore because nothing that was down there is down there any longer.
But to answer my question, you didn't present any photos of the camera in the basement.
There is no camera in the basement.
Okay. Again, to answer my question, you did not present a photo of a camera in the basement.
No, there is no camera in the basement.
I just need a simple yes or no
I
answer.
just said, no, there's no camera in the basement.
You also presented evidence today as respondents exhibit 15 of a video from of the entryway of your home, right?
That's correct.
And that was from December 27th.
Yes.
And there's a clear shot of Mr. Peters in the entryway of your home,
Yes.
but you didn't produce any evidence of that video of it, or I'm sorry, of video evidence of him entering the home on the 24th.
No, because that camera wasn't turned that direction on the 24th. I wasn't expecting him to come in. So, but in case he came in the next time, I turned the camera that direction to capture it.
Okay. Would you agree with me that Mr. Peters is capable of putting Henry's jacket on by himself?
Sure. Yes.
When the park incident happened, you don't deny that he informed Lauren, the nanny, that he was going to the park, correct?
No, but Lauren was caught off guard. Her words to me is she felt like she was in a Lifetime movie.
Stop. No, ma'am. Hearsay.
Okay.
I know, Mr. Alexander, I caught it. That's hearsay. Don't want to hear it.
Okay, so you don't deny that Lauren knew where Mr. Peters was going with Henry.
She knows what she was told.
Okay, your parents also confirmed that Mr. Peters was at the park with Henry.
They did.
Okay, so you knew exactly where Henry was with Mr. Peters when you decided to show up at the park.
I did at that moment, but he had informed me that he didn't have to tell me where he was taking him next.
You've described the historical use of AirTags for your family. You would agree with me that historically they've been used to track Henry when he is with the nanny?
They've been used to track Henry.
They were on the stroller, correct?
Yes.
And they've been, I apologize. But you stated on direct that it was in order to keep track of him while he was with the nanny.
I don't recall saying that. The purpose of the AirTags was to keep track of Henry.
Okay. I apologize, Your Honor. Let me review my notes very quickly. Is it your testimony that you've never wagged your finger at Mr. Peters?
No.
No, that's not your testimony, or no, you never have?
No, that's not my testimony.
So you would admit that you have pointed your finger at him before?
Yes, I have pointed my finger at him.
And you've also poked him in the eye before, have you not?
I did not say that. No, that did not happen.
Okay. You would agree, you admit that you have been aggressive with him vocally?
No, if I've defended myself, yes, but I have not been aggressive with him vocally.
Okay. You admitted on direct though that you do curse at him, correct?
Yes, and he curses at me as well.
Okay. Did you present any evidence today of Mr. Peters cursing at you?
No, because I'm not recording him. I'm not trying to keep track of him, so I don't have recordings of him cursing at me which he does. Seems like reverse stalking, but okay.
It's your testimony today that you're not trying to keep up with him?
No, absolutely not.
Okay. But yeah, you put a AirTag on the bottom of his car.
I'm trying to keep up with my son.
But again, you agree with me that he takes his car to other places than with Henry in the car.
And I don't care when he goes to those other places. I just care when he's with my child.
Okay. Is it your testimony today that if you found an AirTag on your vehicle, you wouldn't be concerned?
I would object. It calls for speculation, Your Honor.
Your Honor, she can testify as to how she would react if she found an AirTag on her car.
Your Honor, she's literally asking her to speculate as to what she would feel if she found an AirTag on her car.
You can rephrase the question and see if you can.
Would you agree with me that it is a reasonable reaction to be afraid when one finds an AirTag on their vehicle?
Is what a reasonable reaction?
To be afraid.
I don't know.
Okay. You testified that there were 2 witnesses to the incident that occurred on December 24th, right?
Yes.
Your brothers?
Mhm.
And you didn't bring them here to testify on your behalf today?
No,
I would object, I would object to that question, Your Honor, based on the fact that, again, we got into this, that there was no allegation within the petition with regards to some physical altercation which occurred on December 24th. She was not on notice to call these witnesses. So I would object to that line of questioning.
Willis,
Your Honor, she knew that Mr. Peters was going to be testifying as to his reasonable fear of safety by virtue of having filed this petition. If she wanted to defend herself, she had ample time to bring witnesses in today.
I mean,
Furthermore, Your Honor, I apologize. Furthermore, Your Honor, one of the witnesses was on the Zoom at the first TPO hearing.
and I think I'm going to allow it because Friday, I mean, she had plenty of time to talk to her, brothers over the weekend and get them here. We went back and forth about the leg slap and or fist in the face or finger in the face. So I'll allow it.
Ms. Peters, again, you testified that there were 2 witnesses to the December 24th incident, right?
Yes, I did testify to that.
And you didn't ask either of those eyewitnesses to come here to corroborate your testimony today?
I just asked one of them and he'll jump on in a matter of minutes if you give him a chance.
All right. Would you agree with me that both of your brothers are intimidating?
No, my husband was texting with him days before this about sports, about where to get Henry's haircut. He's obviously not intimidated by them. They are not intimidating. They're sweethearts, truly.
One of your brothers at least has a pretty extensive criminal history, does he not?
Yeah, as does Alton's brother. I don't know what extensive is. One of them is a recovering alcoholic who went through the program in Gwinnett County and has been sober since. I'm actually very proud of him. The other one got in trouble in college and now has a military clearance. So if we're going to hold mistakes against people in their past, then I guess we should.
I know, Ms. McCollum, but I don't know that your brother would want it aired on YouTube that he's an alcoholic.
I think all of it's public record. He's been arrested for multiple DUIs.
I'm sorry, Ms. Peters, what was that statement? Was that about Mr. Peters' brother?
No, that was about my brother. I don't. But does that mean violence?
All right. Ms. Peters, you admit that you were served with the complaint for divorce on December 20th, right?
I believe so.
Were you aware of the standing order that went into place when you were served with those divorce papers?
I believe I read it then. I don't know that I read it since.
Okay. When did you place the AirTags on the undercarriage of his vehicle?
Well before that.
Do you have any sort of time frame reference?
I mean, I think, doesn't your own complaint say that he found it before a divorce was filed?
I didn't ask when he found the AirTag. I'm asking when you placed it there.
Yeah,
Ms.
I don't
McCollum
know.
Peters, you don't get to ask her questions.
Well, I don't have the documents in front of me to have the answer, so no, I do not know.
He's asking you when you put it on there.
Yeah, I do not know. It was well before. It was before
October, November, December. Random month?
I believe it was November. I can't be certain,
Thank you.
You also testified on direct that you said Mr. Peters did not show an interest in taking Henry anywhere with him, correct? Until this divorce?
No, I did not say that.
You did not testify on direct that Mr. Peters had shown little interest in taking Henry anywhere prior to this divorce.
I said when Henry was 15 months before Mr. Peters bought a car seat and then showed interest of personally taking him somewhere. That's what I said.
If I had the court reporter read back your testimony, it would be incorrect that you said that he had shown little interest in taking Henry anywhere.
I believe that what I said was that he had shown very little interest until he got this car seat. And we were talking about the car seat when I was talking about little interest.
Okay. You would agree with me that you all shared a car seat prior to him moving out of the marital residence, correct?
No, I had a car seat in my car.
And Mr. Peters never used your car,
Occasionally he would use my car.
and he never used your car seat.
He would occasionally use my car to go to the gym, grocery store, and occasionally take Henry to the park.
Okay. Let's see. Your Honor, I have no further questions for this witness.
Any follow-up, Mr. Alexander?
No, Your Honor.
Ms. White, happy birthday again. You've been sitting so patiently. Does the guardian ad litem have any questions for either party?
No questions, Your Honor. I appreciate it though. Thank you.
Okay, so I've just got a couple for you, Ms. McGowan. Both of you folks can figure out if you want to follow up on something. So I'm looking back at my notes. It looks like Mr. Peters said that there were 2 cameras in the living. This could have been in New York, maybe it's here. 2 cameras in the living room, one at one end, one at the other. Thank you. That kind of encompassed the whole living common area where your son would play, and then one in your son's bedroom. So was that here in Georgia also, or was that only in New York?
You want me to answer, Judge?
Yes, I'm asking.
Okay. In New York, we had a 2-bedroom apartment. So one bedroom was where all 3 of us would sleep. The other bedroom was an office. And then there was the main living area. So we had 1 camera in each room. So he had a camera in his office in New York. Here in Roswell, we had 2 cameras. It's a much larger space covering this one common area. And the other one's in Henry's bedroom. I put one in the basement once I saw toys down there.
Okay, so this exchange about this coat that happened in the foyer or in the living room?
It happened in the foyer.
Okay, let's see. That's all right. So I'm pretty sure that something was meant that the nanny knew that there were AirTags or something in the diaper bag, but why did you choose to place them in the wipes? Because one, if she knew, you put it in a pocket of, or something in the diaper bag. Or 2, when she used the wipes, if she would have found it, maybe she'd have been like, what is this?
So these were like hand sanitizing wipes. And sure, she could have found it. But I don't know. I just felt like it was a place where, I don't know. I have not told her about AirTags. I don't know. I'm sure her phone, because she has an iPhone, has alerted her to them. But I don't believe I had a conversation with her about the AirTags.
I mean, has Mr. Peters harmed this child that you would be so worried about where he was with him?
You know what, Judge, I'm completely honest. He has never harmed my child, but he has communicated that he didn't feel the need to communicate with me where he was taking him. He lives primarily in another state. I just, maybe I'm just a mother who's too attentive. We consistently critique moms who don't know where their children are. And I was just keeping up with my child. This whole divorce thing was brewing. And so I don't know. I just was lacking trust in the moment. I still lack trust, but yeah.
So the 27th, that video, did he just stand there and that's when he got Henry? Did Henry go down to him, or someone took Henry down to him in the foyer?
Yeah, I packed up some toys for him to take to his place. I packed up some books for him to have at his place. And so he and my dad, I think, loaded those into his vehicle. And then my mom handed him over to Henry. That's what has been since that 24th incident. We've always pretty much had one of my parents hand him over.
And if your honor would like, for the purposes of being brief, I did not play that whole recording, but that does show, if your honor would like to see that whole recording, it does show that.
Okay, I mean, you're an officer of the court, so you're saying that. I just didn't know if that's where they exchanged him or, if he just.
And to the extent it would be helpful to your honor, apparently, Ms. McCowan's brother is available to hop on to testify.
Okay, does this conjure up any more questions with Ms. Willis, Ms. White, or Mr. Alexander from Ms. Gallen?
Is the court's questioning or does the presentation of an additional witness?
Right, I mean, I'm talking about anything that I asked. Do you have anyone follow up to anything about that?
No, Judge.
Oh, Ms. McGowan, I guess I want to, where else did you keep it? Is that the only place you kept an AirTag in the diaper bag?
There's one on the stroller, one in the diaper bag, and then the others. And then I have one on my keys right now.
So has it always been in the baby or baby, whatever the wipes are?
Yes.
Is that where it's always been? Did he know before that that was in the diaper bag?
I don't know.
When did you put that in the diaper bag?
After we moved to Georgia, because we only really needed it in the stroller beforehand because she was walking everywhere with him. And now we're like, we're driving around with him and not necessarily taking the stroller with us.
Okay, all right. All right, anything else?
Just one clarification, Your Honor. I just want to ask Ms. McCowan-Peters, and I apologize if this has been asked, but I just want to make sure to clarify. Ms. McCowan-Peters, that diaper bag with the AirTag in it, does that belong to you?
Yeah, it's something that it's, I mean, technically Henry's, I guess. It's Henry's diaper bag, but yes, it's in my custody when Henry's with me. It's many times we send it with him when he goes anywhere with anyone, even if it's with my parents.
Okay, thank you.
Anything else, Ms. Willis?
No, Judge.
Okay. Anything else?
No, Your Honor. I mean, as I mentioned, Your Honor, the brother is available to testify if necessary. I would love to get Ms. White out of here and not have to introduce another witness. But if necessary, and to the extent it would assist the court making a determination, apparently the brother is available.
I mean, it's up to you. It's your case, Ms. Willis or Ms. White. Do you have any opinion? Because if he's going to say there was some tussle or, they both kind of canceled each other out. Says that he put his hands on her. She said, did this. So it looks like they were probably tussling over a jacket, but, just, I'm not taking as much weight in that as other things. So if you want to call him and ask him that, then you can.
I just want to make sure. I thought that was a question posed to Ms. White. From my perspective, given the court's statement at this point in time, I think respondent would go ahead and rest, Your Honor.
Okay. No, it was to you and Ms. White.
Okay.
Ms. White, do you have any other questions or an opinion that you want to tell me, Ms. White?
An opinion, Judge?
Sure. I always love your opinion, Ms. White. You're fantastic.
Well, thank you, Judge. As are you. I want to be you when I grow up. Well, I'm on my journey. I'm concerned that the timing of the placement of the AirTags, and I find the timing to be an issue because it seems as if it was directed towards Mr. Peters traversing with the child rather than the nanny traversing with the child. The placement of the AirTag in the undercarriage. As to the diaper bag and the car seat, I absolutely appreciate mother's concern in that regard because of an unknown person being responsible for the child, et cetera. But as to the undercarriage, I am a bit concerned. I find Mr. Peters to be somewhat disingenuous regarding his sentiments or his regard for the placement of the AirTags. I think he probably knew about them. And I'm not entirely impressed that there was, I appreciate Ms. Willis' contention that imminent fear is not a factor in the stalking law, but I'm not entirely impressed that he was fearful because of his entry into the home on 2 different occasions without knocking or alerting the owner that he was of his arrival. But I am concerned about the placement of the AirTag on the undercarriage, Judge.
Is this Judge Newkirk?
Farmer.
Farmer, Judge.
Judge Farmer. That was on the first page. Okay. Closing from anyone?
Yes, Judge.
Go ahead.
Judge, as I previously stated, under the stalking provision of the temporary protective of the Family Violence Act, there is no prerequisite that my client was required to prove that he was in fear of threat of death or bodily injury. He has testified on numerous occasions that he had no knowledge of these AirTags and that historically Ms. Peters has been aggressive with him. We heard evidence of her cursing and loudly screaming at him on 2 separate occasions, Your Honor. And he testified that this was very typical behavior of Ms. Peters during their relationship. He also clarified that although historically he was able to flee from the scene when these incidences occurred, because these have been happening while either Ms. Peters is actually physically holding the minor child or while the minor child is present between the parties, that he is no longer able to flee the scene and leave the minor child there in these circumstances. Ms. Peters has not denied that she placed the AirTags where she placed them. There is no valid reason for them to be on his vehicle, which again is used more often than not when the minor child is not in the vehicle. She has been able to track his whereabouts or was able to track them without his knowledge for who knows how long, because she can't remember when she placed the AirTags where she placed them. She went through overt acts of hiding both the AirTag on the undercarriage of the car as well as on the car seat. Mr. Peters testified that when he found the AirTags, he was concerned for his safety in general because of the AirTags, because he didn't know who was trying to track him. And that's certainly concerning to anyone, any person finding a tracking device on their belongings that they didn't know how it got there is reasonable fear. Then when he did find out that they belonged to Ms. Peters and that she's got a history of aggressive behavior towards him, he became even more fearful and was able to figure out that they belonged to her and then how to stop the devices from tracking his whereabouts. She testified that when the park incident happened on the 18th, she knew very well where he was, not only from the nanny, but also because her parents went and found them and had eyes on him at the park. Yet she still felt the need to leave her job and follow Mr. Peters from the park to the restaurant where he was attempting to take the child for dinner. She's testified about needing to track her child over and over again, but none of these conversations, which easily could have happened between the parties, were ever had. She clearly was doing these acts because she wanted to keep tabs on him and to be able to know where he was at all times. Again, Mr. Peters, I don't know if the conversation here would be the same if the gender roles were reversed here, Your Honor. He is a tall man and she's a petite woman, and maybe that plays into everyone's understanding of what reasonable fear is here, but he's testified more than once that she has made him fearful for his life and for his safety. Now, there was a lot of discussion about what violence is during direct examination of Mr. Peters and what his opinion of violence is, but the statute lays it out for us that it does not have to be fear of bodily harm or injury. The behavior exhibited by Ms. Peters was clearly violent and was directed directly at my client. He testified about when he came in order to file this specific action, and his intention was to file it as a stalking protective order to prevent the behavior that we've talked about today in terms of tracking, in terms of Ms. Peters surreptitiously tracking and recording him. He should not be faulted for not having placed certain things into the petition that he was able to prove during his testimony today. Not only was he advised by Safe Families to file this as a family violence, he was advised by me, and he was advised, Your Honor advised me to advise him that it needed to be the same. We don't know what's going to continue to happen. Again, the standing order did not prevent Ms. Peters from doing what this TPO could, and that is why it's necessary in this case to extend this ex parte order for the next 12 months. Hopefully at that point, everyone can have moved on with their lives and not be worried about each other. But Ms. Peters' behavior has not proven that she is going to listen to court orders, and that her own testimony today, she doesn't really see that she did anything wrong, that she was just trying to keep track of her child. We need this order in place in order to protect my client and protect his safety, Your Honor, and therefore we would ask that this court grant this temporary protective order on a 12-month basis.
Mr. Alexander?
Yes, Your Honor. First of all, it is nothing short of preposterous that there is not any of the allegations.
Hold on, Ms. Wright. So, Ms. Peters, you kind of been looking down. I think you've been texting the whole time, or a lot of the time. So please stop doing that, okay? Go ahead, Mr. Alexander.
Thank you, Your Honor. Your Honor, what I was getting to is that this outlandish idea that the petition for temporary protective order need not include any allegations of violence because they picked stalking as the lane that they were going to go down. So because we went down the stalking course, we're not going to put in anything about violence or threats of violence, or again, I keep hearing this again, typical behavior. Well, if this is typical behavior of Ms. McCowan Peters, it either is typical and therefore is not rising to the level of harassing and intimidating conduct if it's been occurring throughout the entire marriage, or it is something that should have been included in the petition. And it was not included in the petition. The reality is it was not included in the petition because Mr. Peters went to the police, couldn't get the arrest, couldn't get a police order that showed that she was the aggressor and he was not the aggressor. So we chose not to include it in there because that didn't fit the narrative for him, Your Honor. We talk about, and I've heard again, this history of aggressive behavior. Well, that is particularly important for Your Honor's decision-making process here, as well as Mr. Peters' definition of violence, because the aggressive behavior or the violent behavior to which Mr. Peters himself testified to, with the exception of the December 24th incident, of which, again, no arrest was made. Officers could not make a determination of who the aggressor were. The other examples were, let's see, closing the space between the two of them. And his testimony, I believe, was he could have put the child down, but she was holding the child and the child should have just crawled to him. But closing the space, that's something that's making him scared. A finger being wagged in his face is something that's making him scared. That was even brought up during cross-examination. Cursing is making him scared. And I believe it's balled up fists that were making him scared. Your Honor, on Friday, we got to sit through a hearing where an individual talked about making someone else Swiss cheese, overt acts of real threats here. No, there is not a requirement that there be overt threats of physical violence, but it is not, is Mr. Halton Peters afraid for his safety based on the AirTag? It is such person in reasonable fear, there is a reasonableness factor in the statute. It is an objective standard. It is not subjective to Mr. Halton Peters. Maybe he is afraid of a finger wag, but objectively, it is not something that is an overt threat, an act of physical violence, anything that should put a reasonable individual in fear for their safety. Additionally, this statute requires a knowing and willful course of conduct directed at a specific person, which causes emotional distress, again, by placing such person in reasonable fear for such person's safety or the safety of a member of his or her immediate family. There has been no showing here of a prolonged willful course of conduct directed at a specific person. We have 2 cameras that were placed inside her own residence. We have one AirTag that is in a back and forth bag that is used by the nanny, that's used by Ms. McCowan Peters, it's used by Mr. Peters. And then we have an AirTag in the car seat. And then we have an AirTag in the undercarriage of the car. For argument's sake, if Your Honor is going to take the AirTag, and Ms. White offered her opinion that that is of concern to her, and I understand that. But certainly one event is not a knowing and willful course of conduct. It's not one incident. It needs to be multiple incidents, which is a course of conduct placing him in fear for his safety. And again, to Ms. White's point, if you are afraid that someone is going to physically assault you, again, because this has to be fear for such person's safety, not their feelings, not whether they're going to get cursed at, but whether they are in fear of bodily harm for themselves or a member of their immediate family. If you legitimately hold those fears, you do not just walk in to the front door of the person that you are afraid of. She could have been standing there. She could have been at the top of the stairs. If he's really in reasonable fear for his safety as a result of any of these acts, he would not have just brazenly walked right into the front door. When you're talking about reasonableness, no reasonable person would do such a thing if they're allegedly facing their aggressor. That is absolutely not what somebody would do in this circumstance. They would call first, text first, ring the doorbell, knock on the door. We've heard a lot of things about, oh, I just got advice from my counsel. Oh, I just heard, did this on advice of counsel. Well, if she didn't answer the door and he rang the doorbell, perhaps he could have called his counsel. Instead, he put the key in the lock, opened the door, and walked straight in. The reason is because he was not afraid for his physical safety. That is just completely belied by the testimony here today, the evidence here. And at the end of the day, this is Mr. Peters' burden. It is his burden of proof to prove all of these elements. He has not done so. We have no pictures of the alleged cameras buried in the equipment. We have no pictures of the cameras allegedly buried in the cardboard boxes. We have no evidence of actual violence other than testimony, which is challenged. Other than a police report of which there could be no conclusion made. No evidence whatsoever of these things. And holding Mr. Peters to his burden, he simply cannot pass muster for this court to enter a 12-month protective order. As I stated at the beginning of this case on Friday, these are issues for Ms. White's consideration in the divorce, for Judge Farmer's consideration in the divorce, but these are not temporary protective order issues, not when a 12-month protective order can have a direct impact on somebody's life that shows up on background checks and things of that nature. And if he was in reasonable fear for his safety, well, this would be a very different conversation. But the reality is he has not shown that a reasonable person in a similar situation would be in fear for his or her safety. And for those reasons, Your Honor, we'd ask that the court deny Mr. Peters' petition for temporary protective order.
Ms. Willis, you get the last word.
Judge, the Family Violence Act defines violence as a number of different crimes that a person can commit. Those include assault, those include battery. We're not bringing this action under either of those things. All my client was required to prove today was that the crime of stalking occurred here, Your Honor. Of course, the incident on December 24th adds into his reasonableness of fear, but that wasn't his burden to prove every element of a battery or of an assault. We're here today under the stalking portion of that statute. Based off that statute, she's admitted that she's surreptitiously placed tracking devices on his things. Inherently, those are things that can cause fear to someone. He, again, does not have to prove that there was threats of bodily harm. And the respondent is convoluting those different ideas. He's not stating that she has, again, we're not bringing this under a battery or an assault. This is a stalking issue, and he has proven by a preponderance of the evidence that she has surreptitiously placed tracking devices on him, and that is a pattern of intimidation and harassment against him that has caused him concern for his safety. Your Honor, for those reasons, we ask again that the court consider those facts and this under the stalking portion of the Family Violence Act and grant this order.
Okay, and Ms. White, you're good, right? Okay, there's a nod of the head from Ms. White. All right, so I'm going to put this in place, and I'm going to explain why. However, I will let Ms. White's investigation and Judge Farmer make changes to this as he or she, whoever is, Judge Houston, sees fit, and if Ms. White feels comfortable later. Now, this is why I'm doing this, because, and both of you make fantastic arguments. However, fear is subjective in people. It's objective in the law, but it's subjective in people. So who am I to say that a man can't be in fear of a woman? Because if you flip this, and she had said he was sticking his finger in her face or pulled up his fist to her or put AirTags on her, I got a pretty good gut feeling, at least she said, that she'd be pissed. And I assume, Mr. Alexander, you or Miss Willis or Miss White went out to their car, even Madam Court Reporter, and found an AirTag under your undercarriage. You'd be like, what the heck is going on? And it bothers me because there were 3, and he had it set up to go to the fire department to have the car seat installed. So if she had the AirTag in the diaper bag, as she said she always did, then why did she need to put one in the car? Because if he had the kid, he had the diaper bag. So there you go, by default. So she wouldn't be following Mr. Peters, she would be following the child. So then the timing of when they were all put on, since nobody seems to know, so obviously obviously probably the one in the diaper bag came first, I don't know, but then she had to put one on in the car seat. Well, then she had to put one on the undercarriage of the car. Where is he taking my child? Okay, it's y'all son together, and you weren't doing that before. And if you both want to say that, and I have this all the time, people sewing AirTags into kids' coats and things of that nature, and they do it, or they put in a stuffed animal that they send with the child. So there are ways of doing it. And man, you can say you're an overprotective mom, and maybe you are, but you also made this child with Mr. Peters and wasn't tracking him before. So, and he doesn't, and a lot of times victims of stalking, and yes, it was filed under under family violence petition because they were in a relationship. Stalking is one of the crimes that be committed under the Family Violence Act. Present spouses, past spouses, parents of the same child, parent and child, step-parent, stepchild. And violence can be any felony, simple battery, simple assault, aggravated stalking, and stalking. Criminal damage to property, unlawful restraint, criminal trespass, entry without permission. So criminal trespass, that she put it on his car, I mean, you could argue a lot. So you can both agree that if the roles were definitely reversed, Miss McAllen Peters would be scared of this. And I don't even know how big both of you are. If he balled up his fist in her face, whether he hit her or not, she would be threatened and intimidated. So why can't Mr. Peters, although very verbose and cannot answer a direct question, kills me, but he can be scared too. Maybe he can be scared not because when she hits him, it's going to hurt, but maybe he is a man that won't put his hand on a woman, and then she could pretty much, keep beating on him, and he's going to be holding her back because he knows he's not going to hit her. And I know you're shocked, Mr. Alexander, and the upper courts can tell me I'm wrong, or they can tell me I'm correct, as they have many times. But it seemed to the whole time, and a lot of the picture is what I, because you watch everybody's body behavior and things like that, and that's the reason a lot of people don't want to be on Zoom or what have you. We won't go back into that. But I also get really good pictures of people's faces. So I get to watch. People have mumbled some serious names about me, and it's never been judged. They mumble when I could read their lips. But Miss McGowan Peters has pretty much been texting. And it wasn't always texting you, Mr. Alexander. I don't need to see that, ma'am. You were texting because you put it to the side when I said so. But she hasn't been, but I'm not even holding that against her. But ma'am, this is about y'all's children, y'all's child. Y'all need to be thinking about this poor child, because it shouldn't be to the fact when y'all exchange this child that anybody's parents have to be there. Y'all are two grown people. What parents are doing to children today is just insane. And Mr. Peters, I know you're like, don't cuss in front of my child, don't cuss in front of my child. Let me tell you what, if you have a child, you're probably going to cuss in front of them. Now, what words you use is up to you, but at some point, people are going to cuss in front of their child. God knows my folks did in Brooklyn, and they still do. But that's the thing. I think there is a reasonable fear that he can have, and I think he's articulated the best he can. And I say this because there were 3 AirTags, not just one. And while some tactics used for stalking are perfectly legal, which may be cameras set up that he doesn't know of, but some aren't. And I think she crossed the line when she placed the AirTags in there. And I think Mr. Peters probably, if they had not, since they knew before, and I swear he said something about in the front, that they knew that there was going to be something in the diaper bag because of this nanny. So here you go. So if they had talked about it, she says, hey, don't, AirTag is in the, and he knew, but putting it where she put it seems kind of, I don't know. I got a problem with it. But under carriage of the car, that's a little much. And at the timing, this is a divorce, so it's already this. But both people's behavior, yelling and screaming. I just heard the video. He walked in, sir, you have no business walking in her house. I mean, y'all are both not squeaky clean. You have no business walking in her house. Do I feel like this will need to stay in place, the entire time? I don't know. Maybe Judge Farmer's going to, see more and see if there's any more AirTags, any more following, any of that. A lot of people do that for their child, and that's fine. I mean, a lot of adults do that with that Wipe 360 app. Me and my spouse have that for when we travel on the road, we can make sure everything's okay, perfectly fine. But if it was on my phone and I didn't know about it, I got an issue with it. Whether I'm driving her car and she doesn't trust me in it or whatever, but I've got a problem with it. So knowing things is completely different. Hiding it in the car seat, and she hid it in the car seat because he said he was putting it in there. Where is he going to take this child? And a park that you did leave your job and you went to find him. And you said he'd been to the park. He's been to the park. He hasn't caused any harm to this children. And the fear that he expressed could be from you raising your fist. And like I said, a man can be afraid. I am not immune to that. I've placed plenty of PPOs against, women on the petitioners have been men. I like to look at them as petitioner and respondent, parent and parent, not necessarily mother and father. Some people think I do. Some people think I don't. I really don't care what people say. I have to follow the law. According to the law, ma'am, you were stalking. This was stalking. Was it most egregious? I don't want to rate it, but maybe not, but it's stalking, and he's in reasonable fear. And Mr. Alexander and Ms. Willis, whoever represents you in the divorce, is going to tell you, you don't have to tell one another, okay, we're going to lunch, then we're going here, then we're going here, then we're going here, then we're going here. You exchange addresses, you go out of town, you need to let them know, and things of that nature. It's not that you got to let them know everywhere you plan on going when you have your time. You have your child, ma'am, as long as they were here, You can do whatever you want. He has no say-so over what you do when you have your child. When you have your child, sir, you have no say-so over what she does. So there you go. You have, I mean, ma'am, you have no say-so over what he does. This is a person, people. Please let's not forget that it's definitely a person. Final words. I want to tell you that the thing that I do that recognizes stalking is some of it is following victims, spying on it, any kind of technology that keeps track of them. And to me, the AirTag is, I've got one on my backpack because I walk off and leave it in, a friend's house. Thing is, you can't do it. And it's bothersome. The timing, going forward, putting up the other cameras, whatever. Not telling him about it, taking away his access to the Nest cameras, that's all suspect. But like I said, the AirTags, placing on the undercarriage and doing that, can place him. And I recognize that he can have a fear that's reasonable. Although his fear, like I said, to me is objective. But when I look at it as objective, yes, that would make any person afraid to know that someone was following them without their consent. Be it their wife, their whoever, it would still make you afraid, like what's happening. Nobody mentioned anything about divorce. About cheating. But at first, I have to be honest, I was like, does she think he's cheating? It's not, it's about ownership of this child, which nobody owns this child. Y'all can both protect the child without stalking one another or getting irate with one another. Let's see. Ms. Willis, do you have the word order? And y'all have some sort of parenting plan. What words would y'all like to put in there as far as exchanging the child? Mr. Alexander, Ms. Willis. I don't want to always hook up a third party because then I'm committing grandma, grandpa, or friend, to exchange the child.
Judge, there is that temporary order in the divorce that they are exchanging, I believe at the fire station or the police station. I can't remember. It's gone back and forth so many times about which station they're exchanging at, but that seems to be going okay. And I believe from what my client told me, most often it is her parents that are the ones facilitating the exchange. So if that is to be true, we're fine with that continuing, that her parents to be the ones to help facilitate the exchange.
But it doesn't have to be them.
Sure.
Right, okay. And we'll allow any communication between them about the child because, of course, if his name is Henry gets sick, and he's with Mr. Peters, he would need to let Miss Peters know, hey, we're going to the doctor. She would do the same. But
there's an Our Family Wizard provision within the
they got our family wizard. Okay, so if you just want to talk about visitation and reference the temporary order under that case number, Ms. Willis,
okay.
That's only because Ms. Freed is doing a ton of other things. I wouldn't ask you to do that, but I'm trying to be nice to her. It's Valentine's Day, so I'm trying to make sure she has an easy day. Anything else? And like I said, we'll put in there, Ms. Willis, that Judge Farber, Judge Houston can make any changes to this that he or she deems necessary. And of course, with the suggestion of Ms. White. I don't know. I mean, she seems like she felt similar as I did, but like I said, I looked at a couple more things because I was tearing apart the statute. And I will say that, yes, I did say, and I've done that with plenty of folks, they come up and they say, it's my wife and it's a stalking order. Proper to fill out the family violence because you have to prove then that you live together and you have to prove that relationship. So that's why that was, because you don't have to prove relationships in stalking. You have to prove it under the Family Violence Act. So, and that's a more proper form to fill out. So anyways, anything else from anyone?
No, Your Honor.
For me, Your Honor.
Okay, I think Ms. Evans put her email address in the chat. Just make sure you email her all of the forms, all the exhibits, and how do you want the video? Just to email her the video, Ms. Evans?
Yes, just forward the videos as well.
Okay, and just mark them. And like I said, I think they both put their emails in the chat, so you can send them a copy of the invoice.
Will do.
And Ms. White, I guess you want to give her your email address in case they request a copy so she can send you a copy of the transcript too.
I have her email address. I looked it up on the bar directory.
Okay. So
Thank you, Ms. Evans.
okay.
Thank you.
So yeah, if you just email it to me, but like I said, the main point is, Ms. White, you remember this, that Judge Farmer, Judge Houston, or whoever else may hear this at some point in time.
All right. So thank you for all who sat through over 4 hours of content, including part 1. So for anyone who haven't saw part 1 and you just dived into part 2, make sure you go into part 1 and hear how the lawyers went back and forth with each other. Hear the questions for Judge Manning. This was an explosive case, like I said before, of distrust, stalking. This TPO order is just crazy. It goes back to the TPO order that we did about Brian Finneran, the ex-Falcon NFL wide receiver for the Falcons. These cases get heated, and some of them can't be done in 20 and 30 minutes. So we are dropping longer form content. So this is heat, people. Hit that notification bell. Hit the subscribe button, like button. The more you like a video, the more it gets into the YouTube algorithm. Also, support the channel. YouTube, you know, it helps a lot. Super chat, Cap App. We're not here begging them, just saying it's support because we drop heat. It takes a lot of work finding this content, editing, and doing the most. But nonetheless, we will see you in the next video.